ttparliament.org.
The Honorable, the Speaker.
Member for Caroni East, you have 4 minutes left of original speaking time.
Thank you. Thank you, Madam Speaker. I'm just moving out from the pension issue, just to ask the Honourable Minister of Finance, when he's responding, whether he'd be kind enough to consider giving us some information on what, in his estimation and his research as Minister of Finance, how many private pension funds and plans there are in Trinidad, about how many people are affected, and what is the possible value of these private pension plans across Trinidad and Tobago. So I'll move away from that now. Madam Speaker, I want to come to the marketing strategies of some of these insurance companies, and it is addressed in the bill, in one of the parts of the bill. And the marketing strategies by some insurance companies, a lot of these things are written in fine print. Some of the people who go to seek policies and become policy holders, they are unaware of some of the fine prints in it. And when they go to make their claims, this is brought to their attention. And unfortunately, some of the policy holders are unable to make substantial claims and get their redress, because some of the issues that they had to confront were in fine print. So we want to see the marketing strategies that, and I saw that on the regulations, there are proper documentation and what the forms that they have to fill out in their marketing plans. And I hope that these things are adhered to from the perspective of the prospective policy holder, so that underwriters and brokerage people cannot go to prospective policy holders and just give them the superficial information without giving them more detailed information as to how they can be affected in their policies. Now, when people are wronged and when people make claims, sometimes they have tremendous difficulties in seeking redress and getting their claims satisfied. And permit me, Madam Speaker, to just read a small issue written by Governor of the Central Bank at that time, Governor Ewart Williams, and he was speaking at an annual breakfast meeting of the Office of the Financial Services Ombudsman That was on May 8, 2012, and it was reported on the Trinidad Express. 2,000 complaints against insurance firms in 3 years. That's in 2012. We don't know how many there might be now. Might be thousands more. And he said that there are several rogue insurance companies in Trinidad and Tobago whose unethical practices are tainting the responsible image of the industry that is otherwise regarded as a solid pillar in the financial services sector. I go on to quote, permit me, Madam Speaker, in order to capture market share, some companies are prepared to underprice premiums while operating with inadequate claims reserves. Consequently, they have difficulty in meeting consumer claims, says Central Bank Governor Ewart Williams. He said from 2008 to 2011, there were over 2,000 complaints to the Office against insurance companies, primarily for auto insurance claims, which I'll speak about briefly. And the bulk of the claims, he said, were for unfair claims practices, such as forcing legitimate claims
Member
to
for Carey,
litigation.
Is your original speaking time is now spent. You're entitled to 15 more minutes to complete if you so desire. You may proceed.
Appreciate it, Madam Speaker. Thank you. And so the governor of the central bank spoke about underpayment of claims and unreasonable delays in paying claims. I myself have been a victim of it recently when somebody came across a roundabout and they're supposed to give way to all vehicles on the right, hit the left fender of my car, smashed up my lights. It's almost 3 weeks now, and I can't have any redress to it. And of course, I have a 4-year car, but I don't have any. I had third-party insurance, so I can't afford this full comprehensive for a 4-year vehicle. So he said, this is what the governor said. To me, there is the inescapable reality that while most insurance companies operate in a reputable and responsible manner, there are a few that adopt questionable industry practices, oftentimes exploiting the antiquated and grossly inadequate insurance legislation. And here I'm talking about a source of major concern in this industry, said Williams. So the point here is that the governor of Central Bank in 2012, he himself recognized that there are a lot of, in inverted commas, rogue insurance companies who were not settling claims made to them from various areas. Now, I want to ask the Honorable Minister of Finance, who piloted this bill. I searched for it in the bill. Where is the redress for the people who have not met with the expectations, or the expectations have not been satisfied in terms of the payment with regard to the insurance policies? And the Attorney General spoke about the justice system. And not everybody can go to the courts to get their claims settled. So could you help us and give us some area within the legislation that the inspector of insurance companies or the regulator could deal with some of these claims in an efficient and effective manner and quickly, so that these people who feel that they are wronged do not have to go to the courts, because the courts are very expensive. So you might be making a claim for $25,000 or $30,000, but the legal fees alone and the time constraints overpower all of that. So could you kindly look at addressing that situation? Now, I want to raise a few points on the motor industry. In my young days of medical practice in 1974-75, while I was a house officer, working in the emergency department at Port of Spain Hospital for 6 months, we would see accident victims come in, and the line of the trolleys in the emergency department. One is dead, and the other one alive, but injured as well. And the one who is dead is a passenger in the vehicle. The one who is dead is a passenger, and the one who is alive either drunk or fall asleep or bad driving. Now, the issue now, there are a lot of vehicles on the road which are not insured. It's difficult to monitor that, and it's only when they have roadblocks they pick up those who are not insured. So those vehicles which are not insured, whether by third party or fully comprehensive, what happens to the victims and people even dying and have serious injuries connected to that accident, and those vehicles are not insured? I read somewhere that there is a compensation, and a number of the insurance companies come together and put up a fund for dealing with those type of victims. But could you elucidate on that, whether such a fund exists in Trinidad, or if there is a thinking of having a fund like that set up with these insurance? What is the value of it? Through you, Madam Speaker, perhaps the Minister of Finance will tell us what the value of these funds, and how can someone who is aggrieved and who has suffered in a motor vehicle accident where the vehicle is not insured, and what redress there is for them? Can I raise another issue, which is, through you, Madam Speaker, the question of the PH vehicles? We know that the PH industry is probably larger than the legal hired industry, vehicles which are for hire, the H vehicles. Now, when passengers in these PH vehicles, when an accident occurs, are they insured or are they not insured? And if they're not insured, what compensation can they get? Probably nothing. So if we, as a government and an opposition, know that this situation exists where people want to go home and go to wherever they have to go, they jump in a PH vehicle, the vehicle gets in an accident, somebody loses their life, and some people get injured, and nobody is compensated. Is it not time that we, as a responsible parliament, look to enact some type of legislation to protect these people, or whether we enact legislation on the issue of the PH vehicles that are operating nationally? I'm not going to make a judgmental call on that. It is for national discussion on that issue. I think it was raised in one of the previous parliaments, but not anything. They didn't go far in that area. So the whole process of compensation in motor vehicle accidents, whether the PH drivers or vehicles that are uninsured, is one of serious concern for citizens throughout Trinidad and Tobago. And what about vehicles that are not insured and killing people on the road and smashing into other vehicles and killing them? And there have been many instances of that in the past. I want to briefly speak about an area which I have been involved in, as the Attorney General spoke about. He has been in the practice of the insurance industry and had to deal with some litigation in those matters. As a medical practitioner, where members of the public, whether the public sector or private sector, took health insurances with insurance brokers and underwriters and insurance companies. And they have policies for health and for other areas. when they go to have their surgery or go to look after the things that they need, you find that the insurance companies do not pay the required amount that they ought to pay. And they give difficulty to the patients, and the patients have to spend a lot of money from their own pocket to meet the requirements of their surgery or medical care. And they fight and battle with the insurance companies for long periods of time to get their redress. So it's something that when you talk about a regulator or an inspector of banks, that is not going to reach them. So what mechanisms we have on the overall situation on redress of these people or these citizens who have been shortchanged and who have been made to struggle. A lot of them have lost their whole life savings as a result of having to pay bills when the insurance companies ought to be paying the bills. One area I want to get some words of wisdom from the Honorable Minister of Finance, through you, Madam Speaker, is the question of the national insurance system, which is a major insurance that covers almost 600,000 citizens, working citizens and then pensioners. When we read recently that the national insurance system, if we don't do certain things, will be in grave danger of that National Insurance Board meeting the requirements for satisfying the insured, whether from the public sector or whether they are private citizens who contributed to the national insurance. So perhaps he may consider, in his winding up, if he can give this Parliament and the country some information of any proposal that he may consider, or his Ministry of Finance may consider, dealing with this national insurance system where people now are beginning to say, well, we have to pay more in our contribution, but what are we going to get from it? And then there are those who are asking whether the retirement age, whether there will be shifting of the retirement age from 60 to 65 and so on. So these are important questions that we have in the context of what we are debating in terms of the insurance bill. But I don't think that has been addressed in this whatsoever. But it's such an important issue where over 600,000 citizens can be affected and their families affected by this issue. The last area I want to raise is a consideration for the government, which we in the People's Partnership Government had begun working on, and that is a national health insurance system, the implementation of a national health insurance system. Whether it is something to be considered, because, Madam Speaker, Professor Theodore in the Department of Health Economics at the University of the West Indies has been working on this since 1994, 23 years now, and we are nowhere closer to implementing that type of insurance system. We, in our 5-year, the Minister of Health, Dr. Fuad Khan, the member for Barataria Salmon, implemented the health card, which picked up a significant amount of health information, and this perhaps the Minister of Health, the member for St. Joseph, can probably speak about and think about at some time, where the 250 CDAP pharmacies, or pharmacies dealing with CDAP, the information for the patients were on health cards and they could have got their medication across these pharmacies. Now, people pay a health surcharge, a health charge of about $80 or $90 per month, but they are saying, well, we're paying that what we're getting, but it is, they get, healthcare is free in the general public. So they do get a lot of assistance and a lot of support. And some might not get as much healthcare as others, but there is the work of the health institutions, the public health institutions, to give the best care that they can. So the national health insurance system, where employers contribute a certain amount, employees contribute a certain amount, the government contribute for the indigent population, and there should be a pilot project at some part of the country to begin this NHIS. So this is something that I wanted to bring out at a previous occasion, and of course it was not a debate on the health sector at that time, and you, Madam Speaker, rightly indicated that that was not a time for that at that time. No, I'm not
Your time is now spent.
finished. All right. So far.
Member for Digo Martin. Member for Port of Spain North, St. Anne's West.
Thank you very much, Madam Speaker. Madam Speaker, it is indeed a privilege and a pleasure to rise to contribute to this very important piece of legislation, this bill that has come to us via a report from a Joint Select Committee. And at the outset, Madam Speaker, I'd like to take the opportunity to congratulate the Minister of Finance and the Attorney General for finally bringing this important piece of legislation to Parliament, and hopefully for us to get it through with passage this evening. As we've heard every single member admit prior to this contribution, this particular piece of legislation is long overdue and is very necessary to regulate an industry that plays such an important part in the setup of Trinidad and Tobago. And on that note, if I may be permitted to just remind the population of what the Minister of Finance told us in his opening with respect to the importance of the insurance industry, and in particular, the role that it plays in our national economy. The insurance and pensions industries are long-term investors in projects, businesses, the country's infrastructure, Madam Speaker, and facilitate sustainable growth and economic development. The assets of the insurance industry total $49.4 billion as at September 30th, 2017. So that is $50 billion the insurance industry's assets contribute to Trinidad and Tobago. And it also accounts for approximately 33% of the GDP of Trinidad and Tobago. Assets under management for the pension sector, Madam Speaker, total $51.4 billion and account for 34% of the GDP. So right there we have 67% of our GDP between the insurance companies and the pension holding funds companies, and $100 billion of more than which 1/3 is invested in government securities. Madam Speaker, I say that at the outset to put it in context as to the importance that this piece of legislation carries for over 67% of the GDP of Trinidad and Tobago. Madam Speaker, there are many, many gaps and inefficiencies in the current legislation, and one that immediately jumps to mind that has been for many years taken advantage of by those who come to invest in the insurance industry. And I'd like at this moment to just pause and say really what we have to do here as legislators are protect the policy holders, and as my friend Fakarni East was articulating a short while ago, those who are affected by the gaps in the insurance industry. So he was talking about from a general insurance point of view, and in particular motor insurance point of view, and persons who are affected by motor vehicular accidents, which touches a very wide spectrum, a number of people in Trinidad and Tobago, and how we must regulate this industry to make sure that they are properly protected. The pension holders, I'll get to CLICO in a short while, and also those persons who have been fleeced by fly-by-night insurance companies that have come and have gone, and in particular the policy holders, Madam Speaker. So as it currently exists, all that is required for long-term insurance companies is a share capital of $3 million. Madam Speaker, there may have been a time in Trinidad and Tobago where $3 million in an asset base was significant. But in today's world, one claim can very easily exceed $3 million. General insurance companies under the current legislation are only required to have a share capital, Madam Speaker, of $1 million. This gap in the legislation has led to mismanagement, has led to an abuse of the insurance system, especially by general insurance companies, and many policy holders and persons in public in Trinidad and Tobago have been negatively affected. What this bill before us seeks to do, amongst many other purposes, is to close some of these gaps and measures, and I'll get to it in a short while, Madam Speaker, to ensure now that insurance companies have sufficient assets, the type of assets that can be used to cover their liabilities, the statutory fund, but in particular the share capital of insurance companies has now been greatly increased to ensure that should something untoward take place, they would have the balance sheet to back up and not just crumple at the knees, as we say, Madam Speaker. Madam Speaker, speakers before me have referred to the whole CLICO debacle, and in various forms and fashions. I would like to, at this stage, use the opportunity to just add to it and then to go to parts of the bill that I think have been created specifically to close the gaps that we found that happened with the whole CLICO debacle, which we're still reeling from 9 years later because we intervened in 2009. Madam Speaker, the CLICO debacle affected many of our citizens of Trinidad and Tobago, and there were many warning signs way in advance. So, for example, one of the things this bill does under the governance provisions of the bill is it now deals with making it mandatory for auditors to be approved by the central bank, but also for there to be an audit committee that has been approved, and it sets out for the first time specific liability for the board of directors of insurance companies outside of the Companies Act, as the Honorable Attorney General referred to a short while ago. So at Clause 67, it deals now with the duties of directors of insurance companies and puts on them the statutory duty. For the purpose of discharging his duty, a director of an insurance company must act honestly and in good faith with a view to the best interests of an insurer or financial holding company. A director or officer thereof shall take into account the interests of the insurer's policy holders. So, Madam Speaker, what we're seeing here now being put expressly into the statute is protection for policy holders and holding the board of directors personally liable to the policy holders, and that didn't exist before. And this is a step in the right direction of good governance, Madam Speaker. This part of the bill goes on to say what applies to the boards of directors and the applicability and their responsibilities for the first time in a statutory form and manner. If I may at this stage refer to the audit committee, because we found that one of the things that failed CLICO and that whole group was the lack of a proper working audit committee. They just simply didn't exist in certain instances. Where it existed, they didn't take their responsibilities seriously. And now we have, for the first time, an act establishing a mandatory requirement for insurance companies to have an audit committee. At Clause 68, it says, Madam Speaker, the board of directors of an insurer shall appoint from among their number an audit committee which shall consist of at least 3 directors. And it importantly says, Madam Speaker, a majority of whom shall be independent directors. So again, this is a very, not only forward-thinking, but actually current-thinking piece of legislation, because it establishes the whole concept of independent directors in the law. Of course, if they had sufficient independent directors who took their duties and responsibilities seriously enough, we might not, as taxpayers and as citizens, have been facing the $25 billion problem that we did. If they were properly operating audit committees at CLICO, we could have held them responsible if we had this legislation in place. Because this goes on to say, at 68.2, the chair of the audit committee shall be an independent director and a financial expert, recognizing that you just can't put anybody willy-nilly to chair these audit committees. So the days of shams, the days of these billion-dollar empires taking policyholders' money and doing as we now know what they did, because there was a very long drawn-out commission of inquiry into the CLICO and CLF collapse. And we heard there of all of the intercompany transactions taking place. And this legislation now deals with intercompany transactions as well. But focusing on the audit committee and the need for audit committees. And I think my friend for Caroni Central was telling us during the break that at the time, he sat on the audit committee.
Seriously?
And the importance of the functionality of the audit committee. And if I remember his testimony correctly, at the time he was one of the first people or one of the persons who raised a warning as to what was going on. But it's been some time, so I can't properly recall now. Clause 70 of this bill, Madam Speaker, in my opinion, deals exactly with what went on in CLICO and CLF. This is, Clause 70 deals with policies and procedures for transactions with connected party and employees. Again, if this had existed at the time, Madam Speaker, and if it was being properly regulated and implemented, it would have prevented, or it could have prevented, what we are now picking up the pieces and cleaning up, hopefully for the last time. It says, the board of directors of an insurer shall establish and maintain written policies for all transactions between the insurer and 1, connected parties, 2, connected party groups, and 3, employees, and 4, review annually transactions referred to in paragraph 8 to ensure compliance. Because what you found going on with these insurance companies, and that group in particular, Madam Speaker, is a lot of shifting of pieces of paper. So to be able to provide the policyholders with high rates of return, what they were doing is they were just shifting pieces of paper and assets around and a lot of intercompany balances, saying that one company would pay another $100 million, but there was nothing backing that piece of paper, etc. So this legislation is now seeking to regulate those types of situations. It also now provides that the central bank shall ensure that the insurer or financial holding company will appoint annually an audit entity to the satisfaction of the central bank. So one of the claims, one of the allegations that came out afterwards is the regulator, i.e. the central bank at the time, was not doing a sufficient job in regulating the CLICO entity. And another allegation was that the auditors of the company at the time weren't reflecting the audits accurately. So this legislation now is seeking to bring all of those entities, all of those various moving parts of insurance under the umbrella of regulation, and they're giving the central bank the responsibility to even approve the auditors. That is a move in the right direction, Madam Speaker. Interestingly enough, it also now provides for whistleblowing and is providing that auditors or former auditors of the insurance company and other persons, actuaries or former actuaries, can actually provide to the inspector or the central bank any information they want without fear of persecution, prosecution, victimization, etc. Again, a very important element in this bill that is before us, because if this had existed at the time, it may have saved the taxpayers billions of dollars. Madam Speaker, I was referring a short while ago to the whole capital requirement and the inadequacy of the current regime and the current legislation when it comes to the capital requirement of insurance companies. At Part G of this bill, it deals with prudential requirements, restrictions, and prohibitions, and says what can take place now and what is an adequate capital and adequate and appropriate forms of liquidity. Because what we also found coming out of that, Madam Speaker, is an overvaluation of certain assets, properties, etc., that were just shoved into the statutory fund without any proper oversight as to the real value. So Clause 83 now talks about adequate assets. Again, I laud this Parliament, this House, for passing this type of legislation, because it is now requiring an insurer carrying on insurance business, through overseas branches, to maintain and hold adequate assets to support its liabilities to foreign policy holders. Because as we all know, some of our friends in the CARICOM are now making claims on the Trinidad and Tobago government for the liabilities of CLICO and some of its other subsidiaries or associated companies. And if there was this type of provision in place, it would have been specifically to cover foreign policy holders. It also says that an insurer shall maintain and hold adequate assets to support its liabilities to Trinidad and Tobago policy holders. Again, Madam Speaker, a very express clause that would have dealt with a situation such as which we faced post-2009. It talks about at Clause 85, the type of assets that can be invested in, and says an insurer shall invest in assets in Trinidad and Tobago, an amount equal to less than 70% of its policy benefit liabilities, other insurance and contract liabilities, and the surplus of which is derived from participating policies denominated in Trinidad and Tobago dollars. It goes on to talk about 10% of policy benefits. So what it's doing is providing the ratios of the type of assets that can be held by insurance companies. Again, a move in the right direction, Madam Speaker, to ensure that if there's a collapse, for example, in equities markets, etc., it doesn't pull the whole rug out from underneath insurance companies, recognizing, Madam Speaker, that we must protect policy holders in the case of a downturn with respect to the investments of these insurance companies. Interestingly, at Clause 86, it talks about investments to be made in corporate name. Again, what we've learned out of that whole episode is that the investments sometimes weren't held in the name of the company, in the name of CLICO, but held in other company names. And of course, now there are disputes, or there were disputes, as to proper ownership, etc. So this seeks to protect against such instances. Madam Speaker, at the outset, what this bill is seeking to do is provide the central bank with the power and with the authority to properly regulate an industry that I said comprises over 65% of our GDP in Trinidad and Tobago, and an industry that carries over $100 billion of value in Trinidad and Tobago. So now the citizens will know that the central bank is charged with that responsibility, and also the regulator, the inspector, has been given more powers and more authority to deal with some of the things that may happen, and that's under Part 2, administration. Clause 7 says the central bank shall be responsible for the general administration of this act and the supervision of registrants, and shall have powers and duties conferred on it by this act and the Central Bank Act. So this evening, Madam Speaker, when we pass this and when it is proclaimed, we have now put the central bank squarely in charge of that whole $100 billion industry. And we're giving them the powers, and certain powers for the first time, to ensure that what happened in the past should be made to be unlikely to happen in the future. We've also given the inspector a list of duties and powers. At Clause 10, the inspector shall have the powers and duties conferred on him by this Act. 10.2, the inspector shall examine all applications for approvals, registration, permits to be granted or issued under this Act, make recommendations thereon to the central bank, shall cause to be examined a whole number of things and a host of things, and the inspector is given powers, some for the first time, Madam Speaker, to ensure that he or she properly regulates this industry. The central bank is also charged with the duty and responsibility at Clause 12 to collect statistics in relation to insurance business. And we know this is something that takes place now, but is a useful power and also useful for good governance and transparency, that we, the citizens, can look at those statistics and see what is going on in the industry. I'm hearing my friend for Caroni Central saying that it forces the insurance companies to comply. It all comes down to the implementation of the powers we're giving them. I agree with him. For the first time, or On this occasion, we're giving them a lot more powers to properly regulate the industry, but also putting responsibility and duties that never existed before on the directors and the board of directors. So they must take responsibility for that which falls under them. And when it collapses, not run for the hills and claim that they didn't know what was going on, etc., because they now will have personal liability. Part D talks of ownership of insurers. Again, Madam Speaker, I'd like to suggest this is a very important provision because there are instances of persons who have lots and lots of cash in their possession looking to purchase smaller insurance companies, and the whole fit and proper comes into play here. But also this now talks about who can own insurance companies, who should own insurance companies, and who, importantly, shouldn't own insurance companies. Madam Speaker, Section 88, or Clause 88, again is a very important provision that I'd like to draw attention to. It's the approval of certain transactions. And it says, an insurer shall not, without the prior approval of central bank. So again, central bank is the body that's been charged with the responsibility of protecting policyholders' interest. And it says, an insurer shall not, without the prior approval of the central bank, A, directly or indirectly establish or acquire a subsidiary in or outside of Trinidad and Tobago. Madam Speaker, what we've learned coming out of the debacle is that very often the policyholders' money was used and abused by those who were in charge of the company, the insurance company, to just go out for personal ego gratification, whatever it may have been, and purchase subsidiaries or companies that made no sense to the core business of insurance. And God alone knows what was the reason. But with the whole collapse, the people that are affected were the policyholders and those who had put their life savings there, the pensions, the credit unions, other persons who invested. So now we're saying central bank must approve the establishment or the acquisition of subsidiaries. Central bank must also approve, they must get the prior approval of central bank to enter into an agreement for sale or other transfer of any of the subsidiaries or insurers or controlling or significant interest in a financial entity. And that an insurer shall not, without the prior approval of the inspector, enter into an agreement for sale or other transfer of 10% or more of its assets, the assets of any of its subsidiaries. So again, this is done to limit the whole intercompany set of transactions that were found to have been taking place, and may also have limited or made illegal and easier for the state what we know took place post-2009, where the shareholders ran off and sold some of its subsidiaries without the approval of the intervening government. Correct. Madam Speaker, the whole of Section H gets into judicial management, suspension, and winding up, makes it a more effective or provides the opportunity for it to be a whole more effective set of procedures in instances where, unfortunately, insurance companies are wound up, found to be bankrupt or in receivership. And we've had quite a few within 20 or 30-year history in Trinidad and Tobago. It deals with, at Part 4, intermediaries, and says that no person shall, in respect of any class or type of insurance business, carry on business as an agency or brokerage unless registered. Again, this is trying to provide some sort of oversight, statutory oversight and registration process for all of those who participate in this insurance industry that we know is valued at over $100 billion. Part 5 talks about the types of financial statements and returns that are now going to be required in law, and that the auditors and the responsibility that will be placed on the auditors. It also provides for the first time, and again, I suspect this came out of what we had to deal with in the whole CLICO scenario, unsatisfactory financial statements and returns. Because remember, Madam Speaker, up to 2009, these companies were getting audited financials signed off by auditing firms. And now we're providing that where there are unsatisfactory financial statements and returns, with providing penalties and offences, criminal offences, with how those should be dealt with. It also deals with no commingling of funds at clause 150, which is an important provision. It says an insurer shall not commingle the funds of its insurance business with the funds of any other business. That single sentence found at clause 150 can pretty much sum up what drove the CLICO group into the difficulties that it found itself in. And the whole commingling of funds from insurance policies, EFPAs, STIPs, and all of these types of investment paper, and the way that the insurance company that should have been investing in proper assets and other bases to provide return, but what they did is they commingled the funds all over the place. They went investing in I was about to say that, they went investing in liquor all over the place in Europe, in Jamaica, and all of these places turned out to be bad deals. Miami properties in Brickell, and all of these instances. And the only people that suffered at the end of the day were the policyholders, and that's why the government had to step in. And again, thankfully, it is this administration that has finally brought it to a head, and this administration that is now cleaning it up. Madam Speaker, this administration took a decision in the middle of last year when they were being forced by some bad advice from attorneys and some bad advice from former ministers as to how the shareholders should deal with the government. And they forced us into court, and as we all know now, the whole CLF group is it's been put in the hands of joint liquidators, and this government, finally, from 2009 to now, this administration is taking responsibility and are for the first time going to recover all of the money owed to the taxpayers of Trinidad and Tobago. And this legislation here, Madam Speaker, if it were in place prior to 2009, may have gone some way to prevent what we now face. It provides at Part 6, compliance directions and injunctive relief. Again, the injunctive relief is a first time for this type of legislation, and it says where the central bank, so again we see all of the authority for regulatory powers and also for just overseeing the whole industry is placed on the central bank, where the central bank reasonably believes that a person is in violation of this act or is engaged in any activity or course of conduct described under Section 155(1), the central bank may, in addition to or in lieu of other actions authorized under this act, seek a restraining order or other injunctive or equitable relief to prohibit the continued violation or prevent the activity or course of conduct in question or any other action or pursue any other remedy. Madam Speaker, this is a very important power because what we learned is the central bank had tried to intervene on a number of occasions into CLICO and were prevented from doing so because there were questions as to the exact amount of power it had as a regulator. So again, you're giving it the hat and the title of regulator, but not the teeth to do anything. And this would have been an important provision because this would have allowed the central bank to get restraining or orders or any other injunctive or equitable relief. Madam Speaker, recall that time as I stand there making my contribution. I remember the hat that you were wearing at the time and that you had to face some of these instances as the then Attorney General of Trinidad and Tobago. So, Madam Speaker, now, these years later, it is indeed fitting to be looking at this type of legislation and the powers now being given, having learned from our mistakes. As a parliament, we can have a great sense of pride here today because this is one of the instances where, as a country, we've learned from our mistakes. And again, I thank the Minister of Finance and the Attorney General for bringing this type of legislation to protect the policy, to protect policy holders, and to really provide the regulators with the authority and the ability to properly regulate a $100 billion industry. I'll ignore the commentary I'm hearing to my left. Madam Speaker, it also deals with pension fund plans at Part 9 of the bill. And again, this is an important provision, because what happens is the pension holders, the pension fund, the pension holders and pension policy holders went through quite a lot of anxiety. And that is one of the reasons why the government had to step in this instance. And one of the big arguments in 2009 as to why government had to intervene, because of course persons who have worked hard for their whole life, saved and invested in their pension funds, were about to just see it disappear from underneath them. So hopefully now this legislation, if properly implemented and applied, will protect, going forward, the pension policy holders. Madam Speaker, in conclusion, I would really like to thank those who participated on both sides to this product that we found, that have participated in this. And I'd just like to point out for the members of the public, those who did, to bring this piece of legislation importantly to the House today and hopefully to have passage. It was chaired by Mr. Colm Imbert. We had Mr. Attorney General Faris Al-Rawi, Mr. Fitzgerald Hines, Ms. Marlene McDonald, Mr. David Lee, Mr. Suraj Ratan Rambachan, Mr. Stephen Crease, Wayne Sturge, Lester Henry, Daniel Dookie, Clarence Rambarat, and Jennifer Raful. Some who participated more than others, I'm told, at these meetings. But on behalf of the citizens of Trinidad and
West, your original 30 minutes are now spent. You're entitled to 15 more minutes if you wish to avail yourself.
Thank you very much. So, Madam Speaker, I is in the process of thanking this Joint Select Committee for the work that it did, and thanking all the members of the House who have participated in the debate. And Madam Speaker, I hope that this now will provide the right umbrella, the right safety net, the right regulations, regulatory body and authority with a proper implementation, because the insurance industry as well as the policy holders have been screaming out for this piece of legislation. Thank you very much, Madam Speaker.
Member for Chaguanas West.
Thank you, Madam Speaker. Madam Speaker, there's a meeting of the minds today on this motion. And perhaps, and it is reflective of perhaps the mood today in the post-Carnival period. Because earlier today, Madam Speaker, members of the opposition and members of the government met on the anti-gang legislation. And we expect the same kind of continuum and progress to be made in that area. Madam Speaker, when I listen to the Honourable Member for Port of Spain, North, St. Anne's West, it is as if the spectre of the ghost of that $25 billion bailout is embedded in this legislation. And the fact of the matter is that this is not only reactive and responsive to that debacle, but it is also a systemic change that is taking place. And one would have thought that in the spirit of continuum of the governance process, you would not have confined your utterances to only the members of the Joint Select Committee, of the 2016 Joint Select Committee. And just for purposes of the record, Madam Speaker, because the Honourable Member for San Fernando West did in fact say so, but for the record, Madam Speaker, that the insurance bill has been laid in the Parliament on several occasions. It was introduced in 2011 in the House of Representatives on November 25th, 2011, where it lapsed in June 26, 2012. The Insurance Bill 2013 was introduced on May 28, 2013 in the Senate. On this occasion, it lapsed in the House of Representatives on July 10, 2013. The Insurance Bill number 2, 2013, was introduced on November 19, 2013 in the Senate. However, it lapsed on July 30th, 2014. The Insurance Bill 2015 was introduced in the Senate on 21st April 2015 and lapsed in the House of Representatives on June 17, 2015. And merely for the record, merely to reiterate the position taken by the Honourable Attorney General, Member for San Fernando West, that he sat on all the Joint Select Committees under Minister Dukaran, Minister Hawaii, and under also now the Minister of Finance, the Honorable Member for Diego Martin West. So, Madam Speaker, so I want to congratulate all members of the House and all members of the Parliament who sat on these committees. And that therefore, it is clear that when there is a continuum in government, the society progresses and the Parliament redounds to the benefit of the country. Madam Speaker, when the Honourable Member spoke, he spoke of the importance of the insurance industry to the economy of Trinidad and Tobago. And he pointed out that the Honourable Minister of Finance, in his opening remarks, pointed out to the fact that some 33% of the country's GDP flows from this sector. Madam Speaker, so it is in that context, I want to read from a report, with your indulgence, called the Oxford Business Group, the Trinidad and Tobago insurance sector adapts to a changing operating environment, Trinidad and Tobago 2016. At page 1, Madam Speaker, dealing with industry structure. So it's, and I quote, the Central Bank of Trinidad and Tobago regulates the insurance industry. Companies are registered with the CBTT in 3 categories: life insurers, general insurers, and composite companies, which provide both life and general insurance products and services. The CBTT also registers other players such as loss adjusters, brokers, sales staff, and agents described as insurance intermediaries. At the end of 2015, there were 7 active life insurance companies, 17 active general insurance companies, and 7 active composite companies registered. According to the figures from the Association of Trinidad and Tobago Insurance Companies, ATIC, which represents most insurance companies operating in the country, gross written premiums received by its general insurance reporting members in 2014 stood at TT $3.5 billion, an increase of 7.1% on the preceding year, but still below the TT $3.69 billion registered in 2012. Of this total, TT $1.76 billion, or 49.2%, related to property lines, TT $1.2 billion, or 34.1%, to motor, and TT $177.4 million, or 4.9%, to general accident and casualty. The measured gross written premiums in that year, the largest companies operating in Trinidad and Tobago were Guardian General Insurance, with a 40.3% share of the gross written premiums, followed by Tatil, 9.9%, Colonial Fire and General Insurance called Fire, 8.2%, and Beacon, 6.9%. For the life sector, Madam Speaker, the gross written premiums totaled $3.24 billion in 2014, of which Guardian Life of the Caribbean held the largest market share at 45.8%. This was followed by Surgical with a 16% market share, Scotia Insurance with 11.9%, Pan American Life Insurance with 9%, and Maritime Life with 6% of the share. So, Madam Speaker, we recognize the importance of this sector, and we recognize that this legislation, filtered, nurtured, and groomed to reach the stage where it has reached, is important for this country. So, Madam Speaker, and the importance of this was stated by the chairman of the inquiry into CLICO, the CLICO Commission of Inquiry, Sir Anthony Colman, when he stated, and I quote, Madam Speaker, and I want to just merely for the records indicate, and I'm reading from the newspaper of June 23, 2016, Colman report knocks Central Bank in CLICO HCO fiasco. Regulatory control seriously lacking. Madam Speaker, at page 9 of that statement, said Coleman was commissioned under the Past People's Partnership Cabinet in November 2010 to probe and ascertain the reasons for the failure of CL Financial, CL Investment Bank, British American Trinidad Limited, Caribbean Money Market Brokers Limited, and the Hindu Credit Union Cooperative Society Limited. Recommendations were also sought. Proceedings began in March 20th, ending in May 2013. It involved 5 million pages of documents and 77 lawyers. In yesterday's statement, read by Gonzalez, who was the secretary to the commission, Madam Speaker, Coleman referred to the captains of CLICO and HCU in seeking to identify the one characteristic which linked the collapse of HCU with that of CLICO and its associated companies. Coleman said, and I quote, "It was repeatedly claimed that the one motive that drove both Harry Harnarain and Lawrence Dupre to even bigger deals was vision. Yet in spite of all the warnings received from the central bank and the auditors, they went on like Icarus, only to be destroyed by the sun of their own vision." Firstly, the powers of regulatory control of the insurance industry by the central bank are found to be fundamentally deficient. That deficiency was starkly shown by the autocratic style of management of CLICO and the CLF group, and the cavalier manner in which it treated attempts by the Inspector of Financial Institutions to deploy such limited regulatory control tools as was then available, and ignored to a large extent the recommendations as to the management of PricewaterhouseCoopers, the corporate auditors of the CLF group and CLICO. He added, "The problem lies with the inadequate regulatory scope of the Insurance Act, which in recent years has not received substantive amendments to the regulatory powers of the central bank." Madam Speaker, the commissioner, the chairman of the commission, then went on to speak about the draft act then as being an impressive act. That act has been further fine-tuned, and that is why today there is that commonality of support for this motion before us, which contains the Insurance Act 2016. So today, Madam Speaker, we are, as indicated by other speakers, we are arming the central bank and the regulator, the inspector of insurance, with the necessary weapons to deal with errant insurance companies. But even as I say so, Madam Speaker, I wish to add later on in my contribution the recognition that whilst the law remains an excellent piece of legislation, when I read it, Madam Speaker, I was not a member of the select committees, but I felt good about the legislation, recognizing that the cure it was seeking to bring about. And it is a good piece of legislation. It is a good feeling piece of legislation. But the cynic in me, Madam Speaker, seeks to address how can we now ensure that this is really acting in the interests of the consumer of this piece of legislation. Because the solvency part, as my friend Porspin North St. Anne's West indicated, the adequacy of the capital ratios, the risk management, the auditors, the liability of directors, all deals with the whole question of the prudential and solvency requirements. That is fine. But notwithstanding that, I have a real concern that in this piece of legislation, what we have left missing is the whole question of the consumer and how the consumer is going to deal with what has emerged in the insurance sector. Madam Speaker,
Still not clear.
Madam Speaker, insurance started back in the time of Babylon, 5,000 years ago. Madam Speaker, where the merchants found investors who agreed to accept the risk of cargo lost at sea in return for a payment. A transaction that would develop into marine insurance. Today, the insurance sector is a worldwide, a global industry, multi-trillion industry. I just indicated the extent, and the Honorable Minister in his presentation indicated the extent of 33% of our GDP is dependent upon that. You see, Madam Speaker, the necessity of insurance, because there is a necessity for insurance. The world is an uncertain place. You get up in the morning and you hear about terrorists in Trinidad and Tobago, but you have the release of those terrorists because there's no evidential basis to charge them thus far. So it's a very uncertain place. So therefore, Madam Speaker, bad things happen. Sometimes bad things happen to good people and bad people. So your house burned down. Your vehicle crash. Hurricanes pass through your country, rip off your coastline. And then you are left with a situation where everything is gone. So in the language of insurance, Madam Speaker, the bad things that happen and can happen are known as risks. And therefore, it is understood that having regard to the uncertainty associated with life and the loss that can come about, that risk might or might not take place. But if it does, someone will suffer a financial loss. And that is where insurance comes in. The purpose of insurance, Madam Speaker, is to ameliorate the financial consequences of risk by transferring that risk from an individual to a group and sharing the cost of that risk that come along, and to pass it and to share it amongst members. Madam Speaker, and that is, so the insurance works when the insurance company honors a simple promise. Insurance is not a product, Madam Speaker, it is a promise. When a policyholder files a claim, the company will pay what it owes, no more but no less. Insurance does not work when the company breaks its promise in order to increase its profits. So now, Madam Speaker, so I'm going to deal with a concept that has emerged in the 1990s, Madam Speaker, with the large American companies as a result of the intervention of that management company, McKinsey Consulting. McKinsey Consulting, in an article entitled, in The Factory and the Firm, the Future of Claims Handling. So this is the consulting company, the guru of management in the world. And I'm sure the acting chief whip, Dr. Rambachan, will be quite familiar with it.
Yeah, would have taught them.
So what McKinsey did, Madam Speaker, was to make the claims center of an insurance company a profit center. So it is no longer a processing system. It is no longer a due diligence system. It made that a profit center. So what they did was that they could not predict the frequency of things happening, but they could prevent the severity of its impact on the company. So, Madam Speaker, what happened in a situation like that? Immediately, the formula came up. Deny, first, delay, deny, and defend. So that therefore, what emerged is that when you make your claim, the delay starts. Anybody who has experience with an insurance company will know that when you make your claim, they delay. Whereas processing the claim is a basic requirement. Why do you delay? the delay helps the company bottom line. Because they take your premium, they invest your money, and then when they delay, the investment continues to accrue, and your premium continues, and you get, you get nothing. So you get nothing with it. So that therefore, every dollar and every day passes, Madam Speaker, the insurance company that fails to pay means that they have more profits on the investment side of the ledger. Madam Speaker, and many claimants, and this is where I feel there is, and I am hoping that the regulator deals, as the inspector of banks, deals with this principle in the regulation to come, because I am very satisfied with the legislation, but for this area. Many claimants, Madam Speaker, are vulnerable, and they need to be paid. An injured accident victim needs money for doctor's bills and maybe also out of work. A homeowner, after a fire, wants to rebuild his house. Delay, well, that's going to court. Hold on, I want to deal with that because that's the defend part of the mechanism. So remember, it's delay, deny, and then defend. So the legislation says 40 days, in 267, I think, clause 267, 40 days after judgment you must get paid. But there's a whole process. And then, of course, you have a convergence between delay, denial, and litigation in Trinidad. Because when you go to court, crap or smoke your pipe. You have to wait 4 and 5 years before your matter comes up. So it is very, the justice here is very facilitative. Very, very facilitative, Madam Speaker. So delay increases the pressure on the claimant to take what the insurance company offers so that they can meet their immediate financial need and get on with their life. So you understand the psychological pressure. And then I will come shortly, Madam Speaker, to deal with lowballing and stonewalling. So that's part of the practice that takes place in the insurance industry. And that is the market conduct that, whereas we have a schedule dealing with market conduct, it does not deal with the operational market conduct in this country or elsewhere.
We might need an exchange.
So, Madam Speaker, so the longer the delay, the greater the pressure. You know, Madam Speaker, there are times, so that therefore, the delay may take many forms. You might stall and roll things over, stall, and they ask for different reports and that report, stall. Then at other times, they have a delay by investigating a claim. So there's an investigation, and they investigate excessively by procuring more and more information that is not really necessary for resolving the claim, dragging things out after, often exasperating the claimant into submission. And then they might even claim statute of limitations. Yeah, so, but you see, Madam Speaker, the point is that nowhere in the legislation they address this issue, so far. Nowhere. You see, Madam Speaker? So you delay, you drag it on, and Madam Speaker, you know, I find it, and you have to apply things when you, it is a similar exercise carried out by government enterprises to pay contractors. Very, very similar. They delay, first they delay. They delay and they keep, you have to submit again your purchase orders. Your purchase orders, you submit.
Member, relevance, please.
Yes. Madam Speaker, these contractors have their insurance premiums outstanding. And with the delay for their payments, they are unable to meet their commitment so as to secure their property and the wherewithal of their family. Madam Speaker, so you deny the valid claims. You deny the valid claims. And after you deny the valid claims, Madam Speaker, some companies have turned denying the valid claims of persons into an art form. They find different ways and different mechanisms into denying you. So denying is a logical successor to delay. And it is a precursor to litigation. And that is the point. Precursor to litigation. So you delay, you deny, and now you defend. Now when the ordinary consumer, when the ordinary customer of an insurance company has to go to court, you already denied, you paid your premiums, you delayed, you denied, you few years down the road. So that therefore, so this is, and as I indicated previously, when you think in the context of the courts of Trinidad and Tobago to get justice, so what could be a simple claims processing, you cannot achieve that, because when you go into the court, that is the arena of the insurance company, Madam Speaker, not the arena of the poor man in this country.
Yeah. What is missing in this legislation?
Madam Speaker, Madam Speaker, so the tactics of denial, as I indicated, are often referred to as lowballing and stonewalling. Lowballing is when the company makes a minimum settlement offer, thereby signaling that the insurance company is willing to fight the claim and to lower the claimant's expectations. So they go down low. They frustrate you. Stonewalling is defined as refusing to negotiate settlement because the claimants often have limited resources and mounting medical and legal bills. Stonewalling puts psychological and financial pressure on such a claimant. Stress. So you increase stress. Madam Speaker, pursuing an insurance claim is often like a marathon or an obstacle course. And for those who do not drop out or are diverted along the way, the final obstacle in the program is the program of litigation that can wear down and defeat all but the hardiest. So, Madam Speaker, so when we look at what the legislation says, 40 days after judgment, how does that make sense? When you look at the market conduct in Schedule 12, it deals with, and it's good, it's an improvement. It deals with full disclosure, it makes against any kind of fraudulent misrepresentation, and it deals with matters of that nature. But I am concerned about the practice in this country. You see, Madam Speaker, when I asked someone in the industry, Madam Speaker, to give me an appreciation of what really happens, and he indicated to me that, look, you have very good insurance companies, well, good insurance companies, very good insurance companies, but you have, as the central bank governor indicated, rogue insurance companies. And what is really required, and the point made by the member for Caroni Central and the member for Port of Spain North and the member for San Fernando West and the member for Caroni East, that the central bank now is pivotal for the effectiveness of this legislation. Central bank and the inspector of insurances. The central bank, Madam Speaker, I am told, is given with the authority to regulate insurance currently, are aware of the manner certain local insurers operate and do little to correct them. There are insurers who operate fairly with their customers and third parties, and on the other hand, there are a few insurers who are noted for dispensing pain both to their insured and third parties. Some of the unethical practices include: A, refusal to sign for a letter containing a statement of claim. B, claiming not to have received reports from their insured, so they cannot settle third-party claims.
And police reports. Yeah.
C, always offering third-party settlements based on contributory negligence. D, shorter opening hours in the claims department than the rest of the company. Madam Speaker, this is what is happening. This is our reality. This is not the aspirational goals. This is our reality. E, offering third-party limits in accordance with the Act. The limits under the Act are very low and ought to be increased. Many insurers do offer limits that are much higher than the Act requirements. This is an area in law that urgently requires amending so as to increase the limits that have now become inadequate in current times. F, request contribution on third-party claims when in many instances it is incorrect so to do. G, insist that a third party completes a claim form even though he may have supplied a copy of the one given to his own insurer. You see, delay. Not responding to letters written to them. I, frequently claiming not to have received correspondence. J, there is an insurer that has a clause in the policy that allows them to pay the amount of a claim less the salvage to the insured. So the insured has to dispose of the wreck after a total loss claim. K, you own a car from new, so you have a certified copy of ownership that may be 3 years old. Some insurers require one that is less than 6 months old. Certain insurers owe other insurers millions in recovery matters where these insurers have paid their insureds. So, Madam Speaker, you see, in a practical sense, what is happening in this country. You have delay, deny, and defend. I will deal with the whole question of recommendations for the regulator subsequently, Madam Speaker.
Honourable Member for Chaguanas West, your original 30 minutes are now expired. You're entitled to 15 more minutes, if you wish.
I will take my...
You may proceed.
Time. Thank you, Madam Speaker. Madam Speaker, I want to deal now with our reality, because you see, two things. What has emerged with respect to our contractors is that they will need, every time there's a change in regime, and I want to project into the future, insurance. They will need to buy political risk insurance. And it is a... Madam Speaker, because in the current situation, that is what will be in fact required. Madam Speaker, the clause 80 mentioned by both the Honourable Attorney General and the member for Port of Spain North deals with protection for whistleblowers. And the clause is very clear, so I won't go into that within the time frame. So that whistleblowing is an important element. And the Honourable Member for Port of Spain North indicated in his lamentation that that legislation was not available back in 2009 when the systemic risk was so great and it led to the collapse, and that whistleblowing ought to have been there, but it is here now. Madam Speaker, I want to read into the record a letter written to Mr. Patrick Solomon, Inspector of Financial Institutions, Central Bank of Trinidad and Tobago, Eric Williams Paza, so on and so on, dated the 25th of January, 2018. Dear Inspector, I have noted with great concern your letter dated November 27, 2017 and January 22, 2018, and I feel compelled to respond on an individual basis. Both letters speak to an uncertainty by Central Bank of Trinidad and Tobago in the honesty and integrity of the board of directors and management of a particular insurance company. CBTT has also served notice that their assessment of key personnel to meet the standards of fitness and propriety in accordance with the fit and proper guideline is an issue of concern. I write to express my concern over the day-to-day management of this particular company or the lack thereof. But what struck me in this letter, Madam Speaker, is the re-emergence of two of the principal characters in the HCU CLICO financial debacle. And I will go on to read the letter, because it is shocking to say the least. One of the fundamental concerns I have always had, and continue to do so, is the influence that both Mr. Carlton Rees and Mr. Harry Harnarine continue to have on the day-to-day operations of this company. What? Their physical presence on the compound, is further aggravated by the fact that I believe that Mr. Carlton Rees has been removed both as a director and chairman of ICD on the instructions of CBTT. I am also aware that Mr. Rees is unable to get fit and proper approval from the CBTT. I have expressed my concerns repeatedly to the MD and about the fact that Mr. Rees continues to issue directives to the chairman, Mr. Robert Hannan, and the MD. I have repeatedly known my views that as instructed by CBTT, the board must operate independently. So, Madam Speaker, so there's a series of issues. All that we talk about audit. Oh, I'll get you there. Yeah. There is a definitive absence of proper corporate governance in Motor One since the appointment of the MD in April 2017. This is in direct contravention of the required practices as outlined by the CBTT. And he went on to elaborate management meetings, failure to have that, failure of the MD to consult the board on policy issues, internal auditor. Well, the MD has consistently refused to fully pursue the appointment of an internal auditor, despite my having advised him on many occasions that we are in breach of CBTT guidelines. So when we talk corporate governance in this legislation, we recognize that the reality out there, this is 25th January 2018, this is what is happening. Internal Audit Committee. So they went on to talk about the Audit Committee, and they get rid of the auditor. And now they refuse, they only interviewing auditors. Investment Committee. The law provides for certain, the investment committee, the composition and methods of investment. The bill before us. But nothing is happening. A reduction in revenues from agencies, I'm just reading the headlines, and so on, and various other malfeasance taking place in this area. And this is, and I want to close this letter by indicating, and they go on, Madam Speaker, I don't have the time to read the whole thing. I trust that this makes perfectly clear to the Central Bank of Trinidad and Tobago my position in all of this, and I will not be painted with the same brush as that for Mr. Ali, Mr. Hannan, Mr. Rees, Mr. Harnarine, and Mr. Millian. This is Harry Harnarine. So, signed, Wayne Ian Lewis, Director, Company Secretary, Motor One Insurance Company Limited. Madam Speaker, so we have live, we have before us, we have within the embrace of the central bank a whistleblower before us. So, whilst we are very supportive of this legislation, there is need for action to be taken in that context, Madam Speaker. So where you see, we must not make law aspirational. We must make law connected to the reality of our society. Madam Speaker.
Implement.
How much time? Okay, Madam Speaker. Madam Speaker, so how can, I come back to delay, deny, and defend. How can the consumer protect themselves? You will see the consumer and the policyholders in this particular insurance company is totally naked from any kind of protection. And that therefore, how can we, as we move forward with legislation, as we empower this the regulator and the central bank, which is pivotal to the effectiveness of this legislation, how can we do that? How can we make the... First thing we have to do, Madam Speaker, is to make the consumer aware. Information. The regulator has to provide information to look at the company's claim practices so that if when you're shopping for insurance, you can take that into account when they shop for the insurance. If you don't know the claim practices of a particular company, you know, B&L, bunks and lose. B&L, bunks and lose. Other areas, you know. So that therefore the anecdotal evidence is not appropriate in the 21st century. You have to get the regulator to provide that information to the customers, and we want to see that. Secondly, Madam Speaker.
Publish the information.
Yes, it must be made available by publication so that the consumer doesn't buy, for want of a better term, cat in bag. Insurance in bag. Secondly, we must ensure that the rules of the road in the context of claim handling is well known, and that the central bank and the regulator enforce those rules. And thirdly, Madam Speaker, that when all policyholders filing their claims and where accident victims filing their claims, they must have the ability to hold the insurance companies accountable when the companies delay, deny, or defend. Madam Speaker, it is clear that we have reached a certain juncture in our society, that juncture requires us to deal with our economic reality, and that is a juncture in which all institutions must be held accountable to the people. That therefore the legislation that deals with the Services Commission and the Services Commission now have to appear before a select committee accountable to the representatives of the people. Similarly, Madam Speaker, the central bank must recognize that they are accountable to the people, because when we, as the representatives of the people, give you this power, with power comes accountability. So that therefore you cannot be like a harlot. You know? You want power without responsibility. Power must come with responsibility and accountability. And the regulator and the central bank, inspector of banks, must be in that category, Madam Speaker. So, Madam Speaker, with these few words, I point a future direction for the regulator and the central bank, whilst we are fully supportive of the current legislation. I thank you.
Minister. Member for Kuba South.
Thank you, Madam Speaker, as I join this debate on this motion to adopt the report of the Joint Select Committee to consider and report on the insurance bill of 2016. And, Madam Speaker, after having listened to my colleague from Chaguanas East, I feel that I have been exposed to a doctoral thesis here this evening on the insurance industry. And more importantly, Madam Speaker, the member for Laventille West, if you want to join the debate, you can feel and exercise your right following my presentation. But more importantly, Madam Speaker, we have heard a number of technical terms and technical issues being dealt with during this debate on this particular motion on capital requirements, the role of audit committees, the power of inspectors, and the role of the central bank, and so on, Madam Speaker. And this legislation, in terms of the report and the legislation, is a very thick and what we would call voluminous report, which has been presented through the Joint Select Committee. And what is important as it relates to this particular piece, well, this report and the legislation for me, is the impact and the relevance to the ordinary man in the society. And based on my previous background in relation to the trade union movement, the labor movement, the workers of Trinidad and Tobago, and more importantly too, the people who have contributed to the well-being of the credit union movement in this country. Madam Speaker, and it has been established by all speakers on both sides of the debate that this is a very important report and piece of legislation because it has tremendous implications as it relates to insurance companies, regulating the insurance businesses, and more critically, privately administered pension funds in Trinidad and Tobago, Madam Speaker. And we have heard about the history and where we were in 1980 and where we are today in 2018. And we are here today in 2018 in great part because of the commitment of the People's Partnership government under Kamla Persad-Bissessar to deal with the regulation of the insurance industry in Trinidad and Tobago. Madam Speaker, and from my angle and from being a member of Parliament, I have been and a man in the streets throughout Trinidad and Tobago. I have been exposed to the pain, the suffering, and the trauma. I have heard it personally in relation to persons who have invested their blood, sweat, and tears into these insurance companies and in relation to their pension funds, expecting a yield on their investments and better days in terms of their winter days and so on, Madam Speaker. And Madam Speaker, we have all heard about the word collapse. We have heard about ITL and Winshaw and CLICO and HCU and CL Financial and so on, Madam Speaker. And the very fact that we have arrived at this juncture here today, Madam Speaker, and it has been recognized by all for the need to have more robust legislation to address the weaknesses of the industry. And as I said, to protect the very people who are indeed the backbone of this industry, Madam Speaker. And Madam Speaker, in that regard, a number, especially the member for Port of Spain, North St. Anne's West, during his presentation, he referred to the CLICO debacle at large, and he spoke about the importance of the protection of policyholders and holding directors personally responsible, and also he focused on the lack of a proper working audit committee existing at CLICO and so on. And Madam Speaker, this leads me to a statement that was made by the Prime Minister of Trinidad and Tobago on the 17th, or on the, not the 17th, but on the 1st of the 7th month, 2016, as it relates to the Colm Commission of Inquiry, and the Prime Minister indicating, that he was authorized by the Cabinet to make the following statement as it relates to inquire into the failure of CL Financial Limited, Colonial Life Insurance Company Trinidad Limited, Clico Investment Bank Limited, British American Insurance Company Trinidad Limited, Caribbean Money Market Brokers Limited, and the Hindu Credit Union Cooperative Society, with a view to ascertaining why such events occurred and to make such findings, recommendations, observations arising out of its deliberation as the Commission may deem fit. And Madam Speaker, the Prime Minister, during his statement, went on to point out the sequence of events and quoting directly from Hansard, the Prime Minister indicated, the Commissioner delivered his second report on CL Financial Clico to His Excellency the President on the 22nd of June, 2016. The following morning, on the 23rd of June, 2016, the Cabinet was apprised of the receipt of the report, and the Cabinet agreed that the sealed electronic copy shall remain sealed and be forwarded forthwith to the Director of Public Prosecutions for his immediate, and I quote, consideration and comments or advice on the time on which this document could be made publicly in its entirety or partially. This was expressed to the DPP accompanied by a letter which was handed to him along with a sealed electronic copy of the report at 4:47 p.m. on Thursday, the 23rd of June, 2016. And I go on to quote the Prime Minister when he indicated, I must note, Madam Speaker, that by Friday, the 24th of June, the day after the DPP received the report, under the instruction of the Cabinet, with the utmost dispatch, my colleagues on the other side were already spirited in condemnation, invoking the specter of conspiracy and cover-up on the report on the part of the government. Clearly, mistakenly, this government was being wrongly judged by the standards of unacceptable conduct of others well known to us. And this country shall rest comfortably in the knowledge that the government of Trinidad and Tobago, which I have the honor and responsibility to lead, will do nothing to impede the flow of justice in this particular manner. And Madam Speaker, I asked that question, or I am quoting directly from the statement as it relates to the Prime Minister, because the policyholders, all those who have invested their hard-working cash into Clico and CL Financial are still awaiting justice in this particular debacle, Madam Speaker. And probably in the context of the bipartisan approach that we have seen, that we would expect the Prime Minister and his Cabinet to continue to work in the interest of ensuring that justice prevails in this particular issue. And Madam Speaker, also, the Prime Minister indicated that in his said statement, and I further quote, whilst in the last five-year administration, the management of Clico CLF and the associate companies was shrouded in secrecy by the UNC administration. This government has no intention of operating in that manner. This government will operate in an open, transparent, and accountable manner, as it has been doing, and the Minister of Finance has once the Minister of Finance has completed his ongoing audit, he will come to the Parliament and tell the citizens of Trinidad and Tobago the exact amount expended by the government with respect to the said bailout and so on. And we look forward to the transparency and the accountability that the Prime Minister promised in this particular instance, Madam Speaker. And also in giving a sense of hope and to ease the pain and suffering, Madam Speaker, the Prime Minister, and from the point of view as we go on to address the loopholes and the weaknesses in the system, Madam Speaker, and from the bipartisan approach that has been demonstrated in terms of the Joint Select Committee's report and the commitment on both sides to give support to this particular report and the legislation, the Prime Minister indicated too that
Member for Couva South, I've given you a lot of leeway. This is not a debate on the statement of the Prime Minister. This is not a debate on the Coleman report. This is a debate on the particular report of the Joint Select Committee dealing with the insurance bill. I've given you leeway to see where you're going. I will ask you to very quickly make it relevant, if not move on to your next point. Please.
Thank you, Madam Speaker. And I'm guided in regard, I was merely indicating or attempting to make the point, Madam Speaker, in relation to the commitment to ensure that with respect to commissions of inquiry, that persons are brought before.
I've given you, as I said, you started at 6:32. You've had 15 minutes. All right? Please move on to your other point, if you can't tie this to the bill that is before us.
Thank you, Madam Speaker. I'm guided in relation to your direction, Madam Speaker, and it leads me to the very important point, Madam Speaker, as it in my opening remarks where I indicated that this particular report and also Part 9 of this particular bill focuses on the issue of pension fund plans, Madam Speaker. And I am sure that based on what we have witnessed over the last 28 months in Trinidad and Tobago in terms of the number of persons who have lost their jobs, the number of companies that have been closed, and also in relation to persons from time to time may visit constituency offices, and in particular my one. They have attempted to find out of the status of, for example, the pension plan as it relates to Caroni 1975 Limited, old BWIA, and even Telco and Textile and so on, Madam Speaker. It is important to note, and I'm sure that the trade union movement will be very pleased that Part 9 of the, this particular legislation under Clause 216 indicates 216.1 that no person may establish or operate a privately administered pension fund plan in Trinidad and Tobago unless the plan is registered in this particular part. But more importantly, Madam Speaker, what is of importance to persons who would have been employed, for example, in state enterprises that are no longer functional from an operating point of view, or even those persons who have found themselves on the breadline over the last 28 months, Madam Speaker, is that the clause 219.1, which speaks to an amendment in relation to registered pension plans not being valid until it is registered. And 219.1 states very clearly that an amendment to a trust deed or rules or both of a registered pension plan shall not be valid unless the amendment is registered. And additionally, it also, clause 219.2 focuses on where an application for the registration of an amendment is made in accordance with section 218 subclause 5. The central bank shall register the amendment where it is satisfied, A, that the trust deed or the rules or both as amended would not have disqualified the plan from registration under this part, or in B, in the case of a plan which should be harmonized with the system of the national insurance established under the National Insurance Act, that the plan otherwise complies with the requirements of any regulations made under that act for the purpose of harmonization. And in relation to the issue of closure of companies, Madam Speaker, from time to time, we have always heard from workers who have found themselves on the breadline, who took the decision to wind up my pension plan? What are my benefits? What am I entitled to? For example, when ArcelorMittal ceased operations, Madam Speaker, and up till today, persons have been visiting my constituency office attempting to inquire on the status of their pension benefits, and in addition, who took the decision in relation to what is the status and where the plan is going. And Madam Speaker, the member for Laventille West wants to offer some advice to the employees of, or the former employees of ArcelorMittal by indicating that they should go to Roger. But, Madam Speaker, it is clearly, and it offers a sense of comfort in relation or of knowledge that under clause 221(1), the registration of a registered plan shall not be cancelled unless the plan has been wound up. And in addition, Madam Speaker, it goes on to say in subclause 2 that the decision to wind up a pension plan shall be recorded by a board resolution. And in addition, subclause 3 indicates that the central bank, trustees, and management committee shall be informed of the intention to wind up a plan in writing, and within 20 business days of the board's resolution and such notification of the central bank, trustees and the management committee shall have done simultaneously, accompanied by a copy of the relevant board resolution. And Madam Speaker, this establishes, as I said, a trail and a sense of information to workers and trade unions who have the responsibility to represent the interests of workers from a pension plan point of view, Madam Speaker. And in addition to that, Madam Speaker, it is very important, too, that from an investment point of view, in terms of where the funds or workers or employees' contributions, and even where there's a part contribution from employer and employee, that the trustees of the pension plan, they have a responsibility to invest assets of the plan in securities as may be allowed in Schedule 7 and in any other manner as prescribed by the regulations, which is clearly spelled out, as I said, in Schedule 7 and under Clause 228(1) of the legislation, Madam Speaker. And in addition to that, no trustee may invest the assets of a pension fund in the equity, debentures, or evidence of indebtedness of the employer, or any subsidiary or associate of the employer, or any company of which the employer is a subsidiary or an associate. So it gives a sense of protection as it relates to willy-nilly decisions or persons just getting up in the morning and deciding that we will take the assets, the financial assets and contributions of workers and simply put it into schemes that are not sanctioned by the Securities and Exchange Commission, for example, in Trinidad and Tobago. And I think that this is very important, Madam Speaker, and also from the point of view of Clause 226, which focuses on annual accounts and balance sheets to be submitted, and also for Clause 227 as it relates to actuarial investigation, Madam Speaker, because, again, these are two very important issues from the point of view of knowing where my contributions are, knowing where my investments are, and from the point of view of the history of how the trade union movement and also how the credit union movement have grown in Trinidad and Tobago over time. Both movements have taken their funds and so on over time and have invested in pension funds in Trinidad and Tobago. And I think that from a transparency and an accountability point of view, it is of critical importance that this kind of information continues to be transmitted to all and sundry, Madam Speaker. And Madam Speaker, as I said, that so I am very heartened from the point of view that Part 9 of this particular piece of legislation focuses very clearly on pension plan funds and so on, and it would give a sense of comfort to where we are today, Madam Speaker. And Madam Speaker, the issue will continue to haunt all of us in terms of what happened at CL Financial. Arima, let us go there this evening before I have to remind you.
Member for Cuvasol, please don't be distracted. Direct your contribution this way, please.
Thank you, Madam Speaker. My friend from Arima, from time to time, enjoys trying to distract me during my presentation. But Madam Speaker, as I indicated, that what has happened at CLICO and CL Financial and HCO and so on will continue to haunt us. But we must ensure that this is not repeated in the future. And it has been established, especially by my colleague, the member for Caroni Central and Chaguanas East and so on, of the need to go beyond the legislation. Passing the legislation is important and it is laudable, but it is what we do after the legislation is assented to as it relates to giving that sense of hope to the policyholder, to the person who pays his or her premium, and at the end of the day, they want to feel that the fine print in policies and so on do not get the better of them, and they are protected, Madam Speaker. And that leads me to the very important issue of ensuring, because during his presentation, my colleague from Tabakit, during a sterling and incisive contribution, established the fact that between 2008 to 2011, that there have been over 2,000 cases against insurance companies in Trinidad and Tobago. And that was between 2008 and 2011. We are in 2018, Madam Speaker. And I am sure that the figure probably would have doubled, would have tripled in terms of cases that are currently before the supervisor of insurance. And in that regard, Madam Speaker, we hope that the Minister of Finance, through the central bank and the regulator, will ensure, and I know that we have explored this in terms of manpower levels, the support systems and so on, that are needed, Madam Speaker, and to ensure that persons or policyholders get their just due. And Madam Speaker, while I know it is not in the report or it is not in the relevant clauses of the legislation, my colleague from Caroni, Chaguanas East, touched on it in relation to communicating with the stakeholders, just as we would have invited submissions and the Joint Select Committee would have brought stakeholders and so on before meetings and so on. I would implore, too, that in giving a sense of follow-through to this particular report and also to the legislation, when it is assented to, that there is effective communication to stakeholders and the citizens of Trinidad and Tobago in relation to this particular piece of legislation, because in terms of its benefits, Madam Speaker, and the government must not only take out full-page ads as it relates to FATCA, and I see my colleague or my friend from Diego Martin Central is not in the House at this particular point in time, but the Minister of Sport and the Ministry of Sports took out a full-page ad boasting of its achievements.
Member, I think you were going fine. Please get back on track. Leave that point. Move on to your next point, please.
Madam Speaker, and it is very important that we educate the public and we inform the public in a very truthful and transparent manner as it relates to whatever is passed in this particular place, and also from the point of view of governance and ethics in Trinidad and Tobago, Madam Speaker. And Madam Speaker, as I said, that it is important, and I hope that the Minister of Finance, working with the central bank, will ensure that there is effective and relevant communication as it relates to this, the importance of this legislation. Madam Speaker, we have all heard of the role of the central bank and what is needed. And it is my fervent hope, and I'm sure that on both sides of the divide here today, that we will all implore that the regulator must not fall down on the job. And the cabinet of Trinidad and Tobago, like any other stakeholder in this country, has an important and relevant role. And it must not take a soft approach, if anything is red flag going forward as it relates to the people's investment in Trinidad and Tobago. And we must ensure, too, we must ensure at all levels of this particular system that persons who are deemed to be not fit and proper, we must take a very hard line and weed them out at every level of institutions and insurance companies that may.
Member for Couva South, your original 30 minutes are now expired. You're entitled to 15 more minutes if you wish to avail yourself of it.
Speaker, but I will not detain the House too long in relation to my taking some additional time. And Madam Speaker, as I said, we must remove directors, we must remove officers, and we must not flinch in our responsibility, because this Parliament has a responsibility to the people of Trinidad and Tobago, first and foremost, Madam Speaker. And that is why when the People's Partnership Government was there under Kamla Prasad Bisesa, we understood people-centered development and improving the quality of life on all levels. And this is why we focus on the need to deal with the regulation of the industry and addressing the issues. And I'm sure that going forward, from a bipartisan approach, we can indeed address the issues affecting the people of Trinidad and Tobago, and the opposition will continue to support legislation that is in the interests of the people and will always be patriotic to the people of Trinidad and Tobago. I thank you, Madam Speaker.
Member for Diego Martin, Northeast.
Thank you, Madam Speaker. I will not be long. I would just like to respond to some of the issues raised by honourable members opposite. The member for Caroni East had asked for some information on pension funds. The member for Port of Spain North gave some information that I had given in my introduction, but for clarity, the total amount of money invested in pension funds is approximately $50 billion, $51 billion actually, $50 billion in Trinidad and Tobago at this time. All pension funds, $50 billion. And if you want to know who are the managers of pension plans, you can go on the central bank's website and you will see an actual list of matters dealing with pensions. And I actually did a count while we were speaking here, and there are over 175 pension plans active in Trinidad and Tobago at this time. Almost 200. How many? Active, over 175. Almost 200 active pension plans at this point in time. All pension plans that are regulated by the central bank at this point in time. So it's very, very significant, a very significant sector. Now, honourable members opposite made the point that there's insufficient redress for persons who are not satisfied with the service that they get from insurance companies or the payments they get from insurance companies. Now, that is not entirely correct. There are provisions in this bill that are new, and I, for example, will read from clause 34, which now allows the central bank to revoke the registration of an insurer in respect of a number of breaches, but one of them is if the central bank, and the terminology uses the board, but that is the board of the central bank, if the board is satisfied that the policy and practice of the insurer in dealing with claims are unfair, or that there is unreasonable delay in the settlement of claims payable under policies issued by it. So now, with this legislation, if the Inspector of Financial Institutions, because that is the authority under this legislation, investigates an insurance company based on complaints from the public or on its own volition and determines that their policy and practices are unfair or there's unreasonable delay, that is grounds to revoke the license of the insurance company. And that leads me now to a point made by the member for Caroni Central, whether the central bank has the capacity and the resources to handle these responsibilities. Well, they don't have it at this time. They have some capacity, but with their new responsibilities, this is why we have a proclamation clause in the bill. I suspect it will take about 3 months for the central bank to acquire the necessary resources and to put its house in order so that it can enforce the provisions in this legislation. There's also a clause in the bill, clause 155, where it says that notwithstanding any other action or remedy, if the inspector reasonably believes that any person, including the principal representative of a foreign insurance company, has committed, is committing, or is about to commit an act, or is pursuing, or is about to pursue any course of conduct that is unsafe or unsound, has committed, is committing, or is about to commit an act, or is pursuing, or is about to pursue a course of conduct that may be directly or indirectly prejudicial to the interests of policyholders. That's some of the conditions. Is unlikely to make the liabilities due to the policyholders of the insurer. Is likely to continue in business that would result in a loss to the policyholders of the insurer. The inspector may direct the person to cease or refrain from committing the act, pursuing the course of conduct, or performing such acts which, in the opinion of the inspector, are reasonably necessary to remedy the situation or minimize the prejudice, so that the inspector can now issue compliance directions to insurance companies if the inspector is of the view that insurance companies are not acting in the best interests of their policyholders or their customers, can also revoke the license of a company, can get injunctive relief, and so on, so that the Inspector of Financial Institutions and the central bank now have tremendous powers under this legislation, which they did not have before. And, well, this is the responsibility now of the government to ensure that the central bank does what it is supposed to do. One of the things that the central bank will be required to do under this legislation is to issue a guideline with respect to the settlement of claims, because there is, believe it or not, this may be hard to believe, some may not wish to believe this, but the central bank since September 2008 issued a guideline with respect to the resolution of claims and the settlement of claims and the processing of claims and so on. But it is obvious that this was either not enforced or that the powers of the central bank with respect to these guidelines were not strong enough. One of the things that will happen now, and that is why I read clause 155, but the fact of the matter is, with the new clause 155, the central bank can now intervene and take the necessary action. And I can assure you that I expect that this Parliament and the Ministry of Finance will be closely monitoring the central bank with their new powers and the new regime for insurance companies. The member of Chaguanas West complained about questionable practices at an unnamed insurance company, although the member to my right named the insurance company. And I see you are not, oh, you read it, okay. I didn't realize you read it. Yeah. Where it is alleged that there are persons who are not fit and proper running the company. This is the allegation, that there are persons who are not fit and proper running the company and also engaging in questionable practices to the detriment of shareholders, policyholders, and so on. Again, once this bill becomes law, that sort of thing should be a thing of the past. The inspector of financial institutions should be able to move in and under the fit and proper criteria, which does not only apply to directors, but it applies to senior management, so that under this new regime, the inspector of financial institutions will have the authority to move in and deal with a company of this nature that has these questionable characters, so it is alleged, running the business. So it is alleged. I have no policies with that company. I don't know what's going on there. But I trust that the information put into the Parliament by the member of Chaguanas West is accurate, and it is quite shocking to learn that there are persons, those particular individuals who are persons of interest to the authorities, are in fact in charge of that particular insurance company. Madam Speaker, I don't think it is necessary for me to engage in repetition with respect to the purpose of this bill, but I would simply read from the very well put together bill essentials put together by the Parliament, and I would simply reiterate that what this bill seeks to do is to reform the law relating to insurance companies, regulate insurance business, regulate privately administered pension funds, strengthen prudential requirements, including the introduction of capital and financial standards, introduce far more stringent corporate governance requirements for insurance companies, give the central bank the necessary regulatory authority, improve public disclosure with a view to promoting market discipline, provide the central bank with a wide range of preventative and corrective measures, and bring the legislation into conformity with international standards. The bill requires a 3/5 majority. I talk a little more? Okay. If you say so. The bill requires a 3/5 majority, and I want to put on record, I want to thank the member for Tabakit, the member for Chaguanas West, for your comments, and I wish to thank all members of the independent bench, the opposition bench, who participated in the Joint Select Committee. I got no trouble from anyone. I got maximum cooperation. Whether it is because, as you would like to say, that when I am in these committees I have a different persona, whether that is so or not, it is more important that I got maximum cooperation from everybody. They were diligent, they attended the meetings, we went through clause by clause, we got tremendous support from the central bank, we got tremendous support from the Office of the Chief Parliamentary Counsel, tremendous support from my own solicitor, Treasury Solicitors Unit. And I must in particular compliment the representative from the CPC, who we put them under a lot of pressure, Madam Speaker. We gave them deadlines, and we gave them a lot of work to do. There are hundreds of amendments to the various clauses in the bill, and they rose to the occasion every time we asked them to interpret the comments for us, to interpret the issues, and to come up with suitably drafted amendments to address the issues raised, not just by members of the committee, but by stakeholders, the people that we interviewed. I also would like to thank everyone who came before the committee, the insurance companies, the brokers, and everyone else who contributed in. This, for me, was a very gratifying experience, and I would also like to compliment members of the government who took of their time. We're all extremely busy. I would like to compliment the Attorney General in particular for his valuable, useful work, not just in this version of the bill, but in its earlier incarnations as it went through all these Joint Select Committees when we were in opposition, so that everybody pulled their weight with respect to this legislation, Madam Speaker. Everybody did their work. I think we've come up with a very good and workable piece of legislation. It will transform the insurance industry. It will go a long way. It will go a long way to ensuring that the fiasco that occurred with the CLF and CLICO group does not occur again. It gives the central bank, there will be no excuse now for the regulator to say that they do not have the teeth and the intervention powers that they require to deal with an errant insurance company. There will be no excuse. They now have the authority and power to intervene. So, Madam Speaker, I simply, at the end of all of this, again want to reiterate my thanks, my gratitude, congratulations to all members of the Joint Select Committee, government, opposition, and independent, and I beg to move.
Honourable members, the question is, that this House adopt the report of the Joint Select Committee appointed to consider and report on the Insurance Bill 2016. All in favour say aye. Aye. Any against? The ayes have it. Member for Diego Martin, North East.
Thank you, Madam Speaker. I beg to move that a bill entitled An Act to Repeal and Replace the Insurance Act, Chapter 8401, to reform the law relating to insurance companies to regulate insurance businesses and privately administered pension fund plans, and for other related purposes, be forthwith read a third time and passed.
Honorable members, the question is that a bill entitled An Act to Repeal and Replace the Insurance Act, Chapter 8401, to reform the law relating to insurance companies, to regulate insurance businesses and privately administered pension fund plans, and for other related purposes, be forthwith read a third time and passed. All in favor say aye. Aye. Any against? The ayes have it. This bill requires a 3/5 special majority.
Mrs. Robinson-Regis.
Aye.
Dr. Rowley.
Yes.
Mr. Alwari.
Aye.
Mr. Imbert.
Yes.
Mr. Young.
Yes.
Mr. Indarsingh.
Yes.
Mr. Hines.
Yes.
Ms. Kojo.
Yes.
Mr. Garcia.
Yes.
Mrs. Critchlow-Coburn.
Yes.
Mr. Ford.
Aye.
Mr. Dillon.
Aye.
Mrs. Webster-Roy.
Aye.
Dr. Gatsby Dolly.
Aye.
Mr. Smith.
Aye.
Dr. Francis.
Yes.
Mrs. Jenny Smith.
Aye.
Ms. Oliver.
Aye.
Mr. Antoine.
Yes.
Mr. Leons.
Yes.
Dr. Rambachan.
Yes.
Mr. Charles.
Yes.
Dr. Tiwari.
Yes.
Mrs. Noalu Hussain.
Yes.
Dr. Gopeesingh.
Yes. State of vote.
Mrs. Gayadeen Gopeesingh.
Yes.
Mr. Indarsingh.
Yes.
Mr. Padara.
Yes.
Dr. Bodo.
Yes.
Ms. Ramdial.
Yes.
Mr. Singh.
Yes.
You sure?
Honorable members, with a division of 31 members voting for, no members voting against, and no abstentions, the motion for the third reading of the Insurance Bill 2016 is approved.
A bill entitled An Act to Repeal and Replace the Insurance Act, Chapter 8401, to reform the law relating to insurance companies, to regulate insurance businesses and privately administered pension fund plans, and for other related purposes.
Leader of the House.
Madam Speaker, I beg to move that the House do now adjourn. Madam Speaker, next Friday is Private Members' Day, and I would like to ask the Chief Whip, the member for Tabakeet, if he could indicate which matter we will be doing next Friday, please.
Here with the motion that we were debating on diversification.
When is that?
The new thing we were debating on last night.
Kindly.
Honourable members, before I put the question on the motion, there are two matters that qualify on the motion for the adjournment. I now call upon the member for Tabaquite.
Thank you, Madam Speaker. Madam Speaker, I rise to deal with a matter which is entitled simply the failure of the Minister of Works and Transport to attend to urgent matters including collapsing bridges, landslips, and the condition of several roadways in the constituency of Tabaquite, including and in particular Caratal Road Section 1. Madam Speaker, I thank you for allowing me to raise this matter on the adjournment, because on a daily basis, my constituents in Tabaquite are faced with great distress due to the condition of roadways, bridges, and in particular, a number of landslips which have recently occurred in the constituency. Almost all of these require some urgent attention. For example, along the Caratal Road, there are now 8 landslips, and 4 of these have developed over the last 12 months, in particular because of the heavy rainfall. Within the last 6 months, 4 new landslips have also developed on the Brasso-Tamana Road between Brasso-Venado and Los Atajos. And this is where the weather tracking station is. And therefore, it is extremely important that this particular roadway be developed, because you do not want to lead to a situation where the tracking station is cut off. I need not say that there are other landslips on the Caratal Road Section 2, on the Mayo Road, and on the Monrush Quarry Road. Vehicles are being damaged. Believe it or not, emergency vehicles and taxis are refusing to sometimes pass through these roads. And there's a dilemma faced by residents who have to go to the groceries, to go to school. And in particular, those returning home with groceries now have to pay almost 2 times, and sometimes 3 times the normal price of a taxi in order to get their groceries home. Madam Speaker, a couple of years ago, Mr. Deputy Speaker, the San Fabian Road in another area of my constituency suffered tremendous land movements. That was in 2012. And we had to relocate 25 families whose homes collapsed. 25 homes collapsed in that area due to landslips. And I'm trying to bring it to the attention of the Minister that a similar situation does not occur, especially along Caratal. Mr. Deputy Speaker, I have written several letters to the Ministry of Works and Transport addressing these issues, since most of them fall under the jurisdiction of the Ministry of Works and Infrastructure. Madam Speaker, Mr. Deputy Speaker, I'll tell you one very interesting fact. For the period January 2016 to the period December 2017, I have written a total of 538 letters to ministries. 538 letters to ministries in 2 years. Madam Speaker, the Prime Minister says I have no work to do. I'm working on behalf of my constituents. That's what I'm doing. But, Mr. Deputy Speaker, the Prime Minister would not like to know. 538 letters. Yes. And I have all that just for the Ministry of Works. But you know, Mr. Prime Minister, you probably would not like to hear this. But of the letters written to the Ministry of Works, in 2016, 59 of that 538 letters, of that 354 letters in that year was to the Ministry of Works, only 18 were answered. And in 2017, 39 letters were to the Ministry of Works, and only 16 were answered, or 41%. What is more distressing is that while Mr. Hines, as minister, used to write me letters, sometimes very, very insulting letters, I have them all here, very insulting, I wouldn't put them in the record, But from January 2017 to December 2017, I have gotten several letters in reply to my letters from the Office of the Minister of Works, signed by a Ms. Louise Lioto, advisor to the minister. All the letters say the same thing. Same thing. And generally it says, with this letter, we hereby acknowledge receipt of your letter as the subject refers which you submitted to Honorable Minister and so on. Your letter has been forwarded to the respective division in accordance with our procedure, and they shall proceed with inquiries and examination of your issues and requests in accordance with your letter. Upon completion of our internal procedures, you will be contacted both verbally and written, advising of the ministry's position. Please be guided in this matter. Signed, Louis E. Lioto, MS Advisor to the Minister. This was January 23rd, 2017. January 23rd, 2018 has come and gone. I've neither been contacted verbally, nor have I been contacted in written by letter to say what has happened to this. And I should have brought my 538 letters and put it here on the table to understand the kind of contempt with which the members of the opposition are being treated on these matters.
Dismissive.
Right? So, one way, let me just say one thing. Mr. Rohan Sinanan is a decent minister. He has attended to matters in my constituency. I want to be fair to him. Mr. Hines made promises but did nothing. And therefore the Prime Minister had every right to move him from that position because he was a non-performer. But the time has come for me to say to the Honourable Minister, Mr. Sinanan, that look, there are matters that require urgent attention and you have to prioritize. You cannot keep saying that we don't have funds, we don't have this and we don't have that. You have to prioritize in order to get things done. And when homes are being threatened, when the lives of people are being threatened, when like in Lightbourne, where we visited Mr. Minister and there were 2 bridges which are now collapsing at the base, and nothing is being done about it, then you cannot expect me not to come before the Parliament and let the Parliament know, which is my only recourse now, because I'm not going to engage in any kind of demonstration. I'm not going to light fires. I'm going to come where it belongs, the house of the people, and make the representation here. That is what is important. So, you know, I don't mind. Ms. Louis will continue writing me every day. Every day. Yeah, I'm writing the minister. I write the minister, and I get a response from January 23rd, 2017, January 23rd, 2017, February 23rd, 2018 has come, and there has been no resolution. What, you can't tell me 13 months, and some simple matters are not being resolved in constituencies. That shows that you are facing a government of non-performance. You are facing a government who cannot not only solve the big problems in the country, but they cannot even solve the small problems in the country. The one that matter to people in terms of life and limb, Mr. Prime Minister. Mr. Prime Minister, you can taunt me as much as you want by your comments, but you will not deter me from making my point here that your government ministers are failing to deliver to the people of the country.
Member for Tabakeet, address the chair.
Thank you, Mr. Deputy Speaker.
Member for Diego Martin West.
$538 letters in 2 years. I wrote them.
Honourable Member, you have 1 more minute.
What the Prime Minister wants me to do is not represent my people, but I want to disappoint him. Unlike how you may represent your people in Diego Martin West, Mr. Prime Minister, I represent my people in Tabakeet, and I will continue to do that. You are the Prime Minister, and you have access to all the resources. With a snap of the finger, you can get the resources. I have to come here to the Parliament and ask the Parliament to take this matter at hand and to note the matter.
Members.
Mr. Deputy Speaker, the Honourable Minister visited with me on July 29, 2017. He paid a visit to my constituency. And to date, the bridges that we visited, the ones that are collapsing, Mr. Minister, nothing has been done about it. Nothing has been done about it. In several of the letters that your advisor sent back to me, matters were referred to the Drainage Division, and the letter said they'll contact me. I'll give you all the letters if you wish. But no member of the Drainage Division has ever contacted me.
Same thing in
Mr. Minister, Mr. Deputy Speaker, there's a road called Vancouver that passes in front of on the Vancouver Road onto Brasso. And that road is a road used by residents all the time. The road has now narrowed to less than 5 feet. Less than 5 feet. We had fixed up to a certain point, and we were due to fix the rest under the PURE program. But that road, if had bargain and so on, if that road collapses, the only contact you have to come back onto the highway, unless you pass all through Gasparilla, is through that Vancouver Road.
Honourable Member, your 10 minutes has been spent. You got an extra minute injury time. I'll now call on the Minister of Works and Transport.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, based on the motion before us today, which speaks to establish whether there is a failure by the Minister of Works and Transport to attend to urgent matters, including the collapsing bridges and the condition of several roadways in the Tabakit constituency, including Caratal Road Section Number 1. I'm duty-bound to respond once again to this Honourable House on this concern expressed. And in my response to this motion, I will attempt to show and to ensure that the population does not go away with the belief that, according to the statement made, the Honourable Minister has failed to attend to these urgent matters. Mr. Deputy Speaker, I was a bit surprised at the motion in the first place because just about 2 weeks ago, I was accosted by the chairman of the member for Tabakit party who told me, and I quote his words, like, "You afraid Suraj?" He said, because anything Suraj asks for, unquote, he just get. He said, you ain't, again, I open my doors, but he said that I asking you for so much and I ain't getting nothing. But Suraj getting everything. Mr. Speaker, I think Mr. Deputy Speaker, it is important to note, firstly, that the Caratal Road Section Number 1, referred to by the Member for Parliament for Tabakit, do not fall under the jurisdictions of the Ministry of Works. It falls under the Kuva Talparo Tabakit Regional Corporation.
Doesn't even know his own constitution.
Mr. Deputy Speaker.
Members.
Mr. Deputy Speaker, the Tabakit constituency consists of the following roads which fall under the purview of the Highways Division, Ministry of Works and Transport. The Bonaventure Road, the Coruscant Road, Guaracara Tabakit Road, Guaracara Quarry Road, Mayo Road, Pascal Road, Piparo Road, Punam Road. That's in the Victoria West District. And in the Caroni District, the Mamoral Road, Brasso, Caparo Station Road, Guaracara Tabakit Road, Mayo Road. Time run out, I won't go into all the roads, but I do know all the roads the Ministry of Works is responsible for. Based on the last road condition survey conducted, the Ministry of Works, in this 2016, there were sections of the roadway that are very poor to critical in the condition. Some of these roads were identified to originally have been agricultural roads that were developed without adequate road foundation. Many of these roads would have also been constructed on the ridge of the hill. This, coupled with the high clay composite in the natural soil, has resulted in frequent failures of sections of the roadway in the ministry. The ministry evaluation recommends that reconstruction is required in these instances. Mr. Deputy Speaker, it should be noted that the Guaracara Tabakit Road was reconstructed over the last 10 years. Our surveys reveal that this road is subjected to extra heavy axle loading, which is related to quarrying activities at the extreme eastern end of the roadway, which is the main road. This has significantly resulted in damage to the roads, apart from where there have been heavy challenges with wasser leaks, which resulted in further deteriorations. Mr. Deputy Speaker, the Highway Division, in going through the exercises over the last 12 months, have brought remedial work in several roads, unlike the report that is presented by the member for Tabaquite. Repair work went on in the Brasso Road, the Caparo Village Brasso Road, Solomon Holchoy Highway, which is part of the Tabaquite constituency, Coruscant Road, Mayo Road, Bonaventure Road, Guaracara Tabaquite Road, Ghat Road, Piparo Road, and several other roads. However, in addition to the work undertaken by the Highway Division, the program of upgrade road efficiency PURE between September 2015 and August 2017 completed rehabilitation and slope stabilization work on 12 roads in the constituency of Tabaquite. I'm sorry, members, I'm sorry, I've sold myself out. And Mr. Deputy Speaker, just to indicate, I just want to apologize to the members on this side, but between 2011 and 2015, under the PURE program in Tabaquite constituency, $230 million was spent. And if I compare that to the Minister of Finance, who have to give me the financing to fix the roads now in the constituency, over the same period, $18 million was spent in Diego Martin. As a matter of fact, in the entire 3 Diego Martin constituencies, no, $71 million was spent. Compare that to Tabaquite, where $230 million was spent in one constituency. So, some of the roads that were completed between 2015 and 2017 in the Tabaquite constituency, Springland Road I wouldn't go into the 12 roads because I know my time is running out. Despite the roads, and despite most of these roads were under the regional corporation, the Ministry of Works under the PRO unit still went ahead to ensure that the roads remain completed. The PURE unit in 2017-2018 highlighted 21 major works to be undertaken, which mainly consists of road rehabilitation for further program of work in the Tabaquite constituency. Mr. Deputy Speaker, I know the time is running out, but the member spoke about my visit to the constituency and the bridges. Mr. Deputy Speaker, in relation to the bridges, I can firmly state that most of the bridges along the road are in good condition in the Tabaquite constituency. There were 77 bridges overall. During my tour to the constituency last year, I identified one bridge located along Ghat Road, which showed signs of failure and has been included in the BLT program. The 2 other bridges are in good condition. However, because of their narrowness, they have been included in the BLT program. And
Member, you have 2 more minutes.
Yeah. Yeah. Mr. Deputy Speaker, that additional, we opened in the constituency of Tabaquite, we opened 1 bridge in 2017, and the additional 2 bridges to be completed and open in this fiscal year. Payment to Mr. Deputy Speaker, the Ministry of Work is currently completing a list of bridges and landslips spread across Trinidad and Trinidad that are in urgent need of repair and reconstruction. As a result of this, 23 landslips have been identified and have been added to the BLT list for construction. Mr. Deputy Speaker, notwithstanding the many challenges, the Ministry of Works and Transport continue to be proactive in fulfilling its mandate with its limited resources. I thank you.
Well done. I recognize the member for Faizabad.
Thank you very much, Mr. Deputy Speaker, for the opportunity to raise this matter, which is of grave concern to the constituents of Faizabad, namely the failure of the Minister of Works and Transport to repair the landslip in the vicinity of light pole number 69, Thick Village, Siparia Road, which is threatening to close the roadway that serves as a major connection between Faizabad and Siparia. Mr. Deputy Speaker, this is a problem that occurred some 5 months ago in October of last year. I'm bringing it to the attention of the Minister because it is currently posing a tremendous traffic hazard. The location is a blind corner, which is making it accident-prone. In addition to that, Minister, there's a 30-foot drop into a precipice, which of course can endanger life and vehicles. Also, I'm very concerned that there are no lights at night, there are no reflectors on the current road and poor road marking. There's also the situation where recently there has been further collapse of this landslip, and in fact it's threatening now that the entire roadway can be closed off. There's also another issue here, which is the issue of causing delays. Of course, that road is frequently used as the main road from Faizabad to Siparia, so it creates a problem in terms of traffic for school children. It's also a roadway that is used when patients from the Faizabad Health Center have to be referred to the Siparia District Health Facility, so it can create a situation in terms of emergency medical care. One of the other issues as well, Minister, is the fact that it's also creating a health hazard. Because of the collapse, there's now a big pool of water, stagnant water, and that in fact is creating the risk of diseases like dengue, for example, because there's breeding of mosquitoes. And what I've actually received is a letter from a resident here. And if you'll permit me, Mr. Deputy Speaker, just to quote from the resident, the letter. And the resident says that for a lengthy period of time since 2015, there has been a severe landslip that has occurred in the vicinity of my home. This is someone who lives very close to the landslip. The landslip has caused an accumulation of water, which is breeding mosquitoes, that is currently affecting my household, including 2 young children. The water is serving as a breeding ground for mosquitoes, which pose a risk of dengue and other viruses that my children can be hospitalized for. In addition to the mosquitoes, there are large caimans, alligators that have inhabited the water, and that has accumulated, so it's another hazard. So it indeed is a dangerous situation. The other issue why I had to raise this as an urgent matter as well is that in the event that this road collapses completely, Minister, the alternate routes also pose some problems. One of the alternate routes will be the Murray Trace that is presently closed off because of a collapsed roadway, as you probably would be aware. And the other roadways would be the ones that will have to go through the fields and so on. Yeah, and Timital, but through the field roads, which are very narrow roads, very lonely roads, and they can create a hazard for crime and so on. Minister, I do have to acknowledge the fact that in response to my letter of January 15th, your office did respond, again promising an investigation into the matter and to get back to us. But in view of the lack of action, I'm calling upon you. So if I may, Mr. Deputy Speaker, if I can implore on behalf of the constituents, the residents of Faizabad, and many of those outside of the constituency of Faizabad who use this roadway on a frequent basis, if I can ask for the Minister to intervene urgently to deal with this matter. I thank you.
I now call on the Minister of Works and Transport.
Thank you. Thank you,
Mr. Deputy Speaker. Mr. Deputy Speaker, only because the start of the motion was the failure of the Minister of Works and Transport. Yeah, so I will have to go into, based on the motion before us today, which states the failure of the Minister of Works and Transport to repair the landslip in the vicinity of LP 69, Thick Village, which is threatening to close the roadway that serves a major connector between Faizabad and Siparia. I am compelled to respond once again on the concerns expressed there. In response to this motion, I will attempt to show and to ensure the population that based on the statement made, there has been no failure by the Honorable Minister.
Mr. Deputy Speaker, on October 25th, 2017, several reports were received of a landslip which occurred on the previous night along the Siparia Road in the vicinity of 8.5 kilometers and 9 kilometers. The Highway Division conducted a site visit, and it was observed that there was a rubble masonry retaining wall which had fallen. In addition, this matter, the tender documents were prepared by the end of October. So on the 25th it happened. By the end of October, the tender documents were prepared. The project was tendered out on November 14th, 2017. To date, the tenders were received by the ministry and are currently being evaluated. Mr. Deputy Speaker, based on our constant monitoring, it is observed that the wall has moved further away from the road since the initial failure in October 2017. However, let it therefore be established that the ministry continues to monitor the landslip for further activities or movement to ensure that there is no further threat to safety. Mr. Deputy Speaker, I wish to reiterate that the tender are currently being evaluated for repair, and it is anticipated that by the end of March 2018, work will commence to ensure such repairs are completed during the dry season. I thank you.
Honorable members, the question is that this House do now adjourn. All in favor say aye. Aye. Those against? The ayes have it. In accordance with Standing Orders 11 and 12(1), this House now stands adjourned to Friday, the 23rd of February, 2018 at 1:30 p.m.